So you filed a green card application for your spouse, the woman you love, the man of your dreams. You filed a permanent residence application, the I-485, and it was denied. And you're saying, what? How was it denied? Everyone told me this was the easiest way to a green card. We filled it out completely. We did it on our own. Or maybe you went to a paralegal or a notario or some professional and you just thought the process was easy. At one point in time, you might have received a request for evidence and you didn't take it seriously enough, or those persons helping you didn't take it seriously enough, and now you have a denial on your hand. So what to do? Well, let me ask you this. When is an adverse decision not the end of the story? Answer: when you challenge it. When I was in law school, I had a professor who posed this question to us. The law is the law until you change the law. And so, a decision is a decision until you change the decision. And in this presentation, I'm going to go through two mechanisms that will help you fight back. To help you fight back from an adverse decision from the United States Citizen and Immigration Services, a case that you believe is winnable and that you should have won, and that maybe you did, but there was error. It starts with a decision, and the back of the page, page 2, the second page, usually will tell you, or sometimes if the decision's a little longer, it may be on page 4 or 5 or 6, and it says you have 30 days to file a Form 290B, a motion to reopen or reconsider, if you disagree with our decision. And so we're going to go through how you respond, how you fill out that form, what you're looking for, what evidence you're looking for, what you're going to prove. So let's begin. First, with a motion to reopen. What is a motion to reopen? Well, a motion to reopen seeks for USCIS to reevaluate its decision based on new evidence or changed circumstances. It's based on facts. It's a factual based opposition. Now, some people come to my office and they want to fight back, and they have evidence that after I explain what they need to give the government or what they should have gave the government, they have. Well, that's not going to work, because if the evidence was there already and you didn't give it, well, then you're out of luck, because basically they're looking for evidence under this motion to reopen that was not considered before because it was unavailable or because something changed. Now, that doesn't mean all hope is lost, because basically, when you get the denial, you have three options. The first option is you could do nothing. And of course, I don't recommend that. And that's probably not going to fit your need. Why would you file a permanent residence application for someone you love and then not fight back so that the person wins? You want to live with this person. You want to have a life with this person. The second possibility is you could refile and restart the process. And sometimes that's the better, of course. But sometimes you want to hold off on that, and instead you want to challenge first the decision. And so you need to file perhaps a motion to reopen. That's based on facts. But remember, the facts have to be something that was unavailable or something that changed since the initial filing. I had a case where an individual was challenged because they said the birth certificate that he had provided wasn't adequate enough. He was from Cuba. And so they were saying his birth certificate is not good because, and they went through other documents, a passport, other documents, his US ID, and his name was spelled differently. Well, he couldn't get an original birth certificate because of the U.S. and Cuban dynamics, the relationship. So he couldn't just reach out to family members there and say, hey, get me a replacement birth certificate. It wasn't going to happen. In that case, we had to introduce new evidence as to where the errors occurred. We had to introduce the evidence about the U.S. government, his efforts to try to get a birth certificate or explain why the name was changed. We had to introduce evidence that his mother was pretty much illiterate and that some of the documents were signed by U.S. government officials when he got on the boat to come to the United States. New facts. They were unavailable before. He thought his birth certificate was legitimate. He had been using it for 30 plus years. Another example is an individual had filed and they had asked for his criminal past, his arrest history, his detention history. And in his initial filing, he and his wife had provided those documents. Then the government asked him through a request for evidence for more evidence on the criminal records. And he went and got more records, certified records, submitted that to immigration. And then USCIS still denied his application, saying that those records didn't match the conviction records. Well, what happened there was that the government had simply not looked at all the evidence. Had they looked at the original set of evidence and saw the case numbers and how they had been changed by the court during the criminal proceedings, they would have seen that all the records matched. So it wasn't that the evidence hadn't been submitted. It's just it hadn't been put together, but the evidence was always there. I had another individual whose birth certificate was rejected because he said that's not the birth certificate being used by that person's home country. We went through the National Visa Center's rules and regulations and found out that, yes, there is a certain format for birth certificates for that country. However, they mentioned that years ago, 30, 40 years ago, there was a different form and that most of those had been destroyed because of, the country's chaos. And that's what he had, one of the old ones. We had to introduce new facts, the facts of what the U.S. government itself said about the old birth certificates. With that, his case was approved and he moved forward. That's a motion to reopen. That's one way to fight back. Sometimes the government makes mistakes on facts, as you'll see. They read things wrong or they don't read things thoroughly, or sometimes additional facts are necessary. Here's a second way to challenge: a motion to reconsider. A motion to reconsider again asks USCIS to reevaluate its decision, but this time it's based on law. It could be incorrect reasoning on case law or the way a statute has been interpreted. It could be the fact that the law has recently changed and the officer making the decision just doesn't grasp the change. In one case, a couple came to me because the individuals had been denied at the green card interview because the couple was not living together. And they didn't have a lot of evidence of being together. And the government's ruling said that they did not meet the requirement of a bona fide marriage. It wasn't a legitimate marriage in the government's mind, authentic marriage. And we contested it legally under the interpretation of what is a bona fide marriage. We showed that, one, really the question is, does this couple have an intent to remain together when they got married? At the inception, when they first got together, was it a legitimate marriage? And even at the time of the interview, they weren't divorced. They didn't even have a legal separation. They were physically separated. They were cooling off. They were chilling out, thinking about where they want to go. There was no grounds for the government to say it wasn't a bona fide marriage. Not all bona fide marriages work out. In fact, statistics in the United States show 50% of marriages don't work out. So the government erred in saying that simply because they weren't together now, it wasn't a bona fide marriage. In another case, we had an individual who had filed under her husband, female immigrant filed. Her husband had sponsored her. We went to the green card interview. And part of the basis of the filing was that the female was grandfathered in. Now, grandfathering is a policy or law that allows the old rule to continue in effect, even though the law has changed for current cases. So she had a petition approved years ago by a father. She went to this interview. That should have moved, even though she had entered without permission, hadn't met the requirement that's normal for adjustment of status. And so even though she didn't meet that requirement, she fell under the grandfathering rule. And the officer said, no, that's not good because the petition filed was never approved. Well, that's not the law. If it was approvable when filed, if there was some technical problem, some minor issue there that prevented it from being approved, but otherwise it should have been approved, then it still counts for purposes of grandfathering. Sometimes motions to reopen and motions to reconsider can be combined. And strategically, sometimes that's the best way to do it. There was an individual called me once. He had been married in Uruguay, but not married in the formal sense. He had a common law wife, had a child, had lived with her for 4 years, and held her out as a wife. And, common law marriage was okay there. But he eventually didn't get married, and the couple eventually broke up. He came to the United States on a valid tourist visa and then met his wife, who later sponsored him for permanent residency. They went to the permanent residency interview, and the government denied it. They saw information about his child and his former common law wife, and they denied it, said that he wasn't formally divorced from his first wife. Therefore, he couldn't legally be married to his second wife. Thus, she couldn't file for him, so he loses his green card. Well, the rule in Uruguay is 5 years. For it to be a legal common law marriage, it has to be a 5-year requirement. So, at that time, that was the rule. We submitted the law. Officer was wrong. Again, it was a legal error. And once again, once that legal error was presented to the government, the immigrant won permanent residency. So when you file for permanent residence, don't assume that just because the requirements look simple that they are simple. And don't assume because the government denies you your application that they're right. They could be wrong. They're human beings. Human beings make errors. All of us do. The question is, are you willing to challenge them and say, wait a minute, I believe you made an error, and here's the error you made. And if you show it, either with a motion to reopen, which is heavily factual oriented, or a motion to reconsider, which is based on legal rules, or a combination of the two, you can win permanent residency. And you and your spouse can live the life here in the United States that you truly want and deserve. Take care. Thanks for watching. Know someone who might be interested in this video? Then please take a moment to like and share it with them. Also, if you would like more videos on immigration, just click on the subscribe button. And here's a little bonus, a short guide that you can download for free by clicking on the link on the description box or the square-shaped image. Plus, if you have ideas for videos you'd like to see, write a short comment below or feel free to contact me at carlos@bataraimmigrationlaw.com. My name is Carlos Batara. I appreciate your time and hopefully we'll be talking again very, very soon.